All right. Last time we were talking about criminal law and how it differs from civil law, and we were saying that unlike tort, you have to have an intent to harm somebody. We said that the harm has to affect the social order, that is, rather than just private harm. That the plaintiff was the state and not the individual. That you had a higher standard of proof, it's beyond reasonable doubt rather than the preponderance of the evidence. And then finally, the defendant is punished if you found guilty. And then we talked a little bit about intent, and we said that it has to be it's not just a careless act, right? That tort law is for accidents. When we talked about public harm, we started to talk about the fact that under property law, we were talking about trespass, and we were talking about if we were talking about contract law, we were talking about breach of contract, and when we were talking about accidents, we were talking about where you caused a private harm to somebody else. So all those situations where one person was harming another person, right? So there's two individuals or two groups or whatever where the harm's happening. And we said that in criminal law, there's, in a sense, a threat to the social order. And what did we mean by that? And we said, we talked about Mises, again, those that had 105. We talked about Mises' liberalism, where he said that stealing disrupts the social order, so you got to have a government there to protect property rights, not just to compensate someone from your doing something to them, but rather there's if you had people killing each other or you had people stealing from one another, then the system just wouldn't work. And that led us to just a thought about, just a quick comment about victimless crime. Could they be a threat to the social order? Now, some people might argue that they would be. For example, prostitution is legal in Nevada. I don't know if it's legal anywhere else, but other states it's not legal. And why would that be? It may be a threat to, in some sense, people might be thinking this is some sort of threat to the social order if we allow these transactions to occur. Whereas in Nevada, they look at it as, okay, this is a private transaction between two people and is not a threat to the social order. So again, there's this just to give you guidance on why the law might look the way it does in one places and look the way it does a different way. Mises, again, in liberalism, he talks about sale of alcohol, which was illegal at the time when he wrote the book in 1927 because prohibition was there, and he argued that this was that private transactions, if you allow the government to come in and stop private transactions, there's no limit on that, right? Because he says he talks about alcoholism, morphinism, and cocainism are all pernicious evils. But he says, but what happens, if you have the government stopping these transactions, what about caffeine? And he starts listing other things that the government would start doing. And so there's no limit on what your government might be doing if it could preclude transactions that it didn't think, that it thought sort of addressed the social order of some kind. And of course, we saw that prohibition was overturned, right? I mean, we had prohibition and it was a constitutional amendment, and so it was a pretty big deal to overturn a constitutional amendment. So there must have been a change in the view of whether this was in fact a threat to the social order. And then the last point is there's an attempt to do harm, and why is this in here? Notice that in tort law, you can't sue if you're not harmed, right? You can't sue somebody because, oh my gosh, they almost crashed into my car, and I got all nervous, and that made a bad day for me. You can't sue somebody, right? So in tort, right, you can't sue if you're not harmed. right? If you're not actually harmed. But in criminal law, you can. It's called inchoate crime. That is, you could be, and for an attempt to harm, it could be a criminal offense. And that would be because it may disrupt the social order in a sense. That is, you attempted to steal my stuff and you actually didn't get away with it, or you attempted to shoot me and you didn't, and you missed. We could still have a criminal offense there because society, in a sense, has a right to feel that they're in a peaceful situation, right? That is, society to feel secure. Right? That is, if you had a bunch of people out there and they were always trying to steal stuff but not getting away with it, you'd still want to be able to have a criminal offense. So we've talked about intent, we've talked about the public harm. Now let's just talk a little bit about the standard of proof. And why might you have a different standard of proof under criminal law than under tort law? So remember that under tort, as we've mentioned, it's basically a preponderance of the evidence. That is, your attorney, or you, if you're representing yourself, your attorney demonstrates that, yeah, it's pretty clear that this person caused the accident and they were negligent while they were doing that, if you have a negligence rule, etc. And so the court or the jury, or whoever's making the decision, is able to say, yeah, it's pretty clear, right? Whereas in criminal law, just mentioned, in criminal law, it's beyond reasonable doubt. Okay, so why would you have it that the standard of proof being greater under criminal law? And there's really sort of three reasons that one might think about. So three reasons that you might have a higher standard of proof. The first of these, if you go back to ECON 206, right, where you took statistics, what did you learn about? You learned about type 1 and type 2 errors. Right, how many, there were also, you might have been called alpha errors and beta errors. How many, remember that at all? Okay, yeah. So in statistics, you learn that, okay, the type 1 error is a false negative. And in this particular instance is that the person committed the crime, but you said, no, they didn't, right? So in that case, in this particular example, you have the person committed the crime and it says not guilty, right? So that you have a situation where the person stole the money, but in the end of the case, the court rules, no, they weren't guilty. A false positive is a type 2 error. If you had a type 2 error, then what you'd be saying is that the court says guilty when they weren't. When really not guilty, right? We would call that a false positive. They said yes, they were guilty, but they really weren't guilty. So if you think of, if what happens is the cost of one error is greater than the other, you're going to weight things towards the one that is, so you're going to try to minimize that error that's more costly, okay? Just like we've been, talking about all the time, right? Trying to minimize the social cost here, all right? So if it's more costly for a type 1 error, or more costly for a type 2 error, then you'll weight the standard of proof. Remember when you were looking at, if you're thinking back to ECON 206, you would think about you have to, there's a certain probability that you have to have that it's true for you to accept the null hypothesis, okay? So similar idea here. That is, if you convict the innocent person, that cost is greater than a not guilty for a criminal, then you're going to have a higher probability that you accept the null hypothesis, okay? In the statistical sense. But what we're saying here is if the cost of convicting the innocent is greater than letting some convict go or some guilty person go, then what are you going to do? You're going to have a higher standard of proof. So what happens? Okay, a guy or some person stole a car and they get away with it, right? There's a cost to doing that for society. But but suppose that what happens is this person really didn't steal the car, and you put them in jail for 3 years, and then so they can't earn income over the 3 years, and then they get out, and then when they try to get a job, they're a convicted felon, and right? You might think, yeah, okay, maybe we ought to have a higher standard of proof when we're trying to see if we're going to convict someone of a crime or not. Second thing is remember that in tort law, it's private parties that are going against each other in the sense that you hire an attorney or you represent yourself, and whoever is the other person in the conflict, they hire their attorney. In a criminal case, we said it's the state that's on the state's the plaintiff, right? And so the state generally, so we can think about a second reason, the state generally has more resources than the person that's charged. So if, let's say you are sort of lower socioeconomic status and you get arrested, okay? Then when you go to court, do you have enough money to hire an attorney, right? If, let's say, you're unemployed and or you're a single mom or whatever, okay? Can you hire an attorney? Well, we allow you, right? The court will appoint you an attorney, right? But your resources that you have are less than, generally, what the state's going to have when they are trying to prosecute you. So to offset that, we might say, okay, we got to have a higher standard of proof. The state has more resources than the potential, the person that's being charged, and so we're going to offset that advantage by making it that the state has to bear a higher burden of proof in order to convict you. A third thing would be basically a political situation where if you have a overzealous prosecutor, so if we have an overzealous prosecutor, and why would that be? If you are running for Attorney General, or you are, or you were an Attorney General and you're running for, I don't know, Vice President of the United States. Not that that would happen, right? In fact, we do, right? I guess the decision isn't going to be made for quite a while, but one of the candidates for vice president was Attorney General in California. Attorney General is an elected position in a number of states. Your prosecutor is an elected individual. I don't know if you voted in the recent election here in Hillsdale, right? Neil Brady is the county prosecutor, and he was running for re-election here. Okay, so what if you think that from a political perspective, you're going to get more votes if you've prosecuted a whole lot of people, right? I mean, what if you're running for prosecutor and you're running for re-election and in 4 years you've never prosecuted anybody, right? It's going to be hard to win a re-election that way because, your opponent will say, oh my gosh, this person's been here for 4 years and never prosecuted a person at all. Why would we vote for them? So there's a political incentive certainly for elected officials to prosecute people. And so if that's the case, then what you might want to do is, again, have, as we've just been saying, a higher standard of proof. We're going to say, you know what, basically it's protection against the sort of the public choice aspect of what would happen with a prosecutor that is an elected official, or as maybe even if you're a prosecutor, your attorney general or whoever is not an elected position, they may be using it for an elected position in the future. All right. So that takes us to the next thing to just talk about briefly is this idea of punishment. And remember, in tort law, the idea is to compensate the other person, right? If you cause an injury, what are we supposed to do? You're supposed to put the other person back to wherever their original indifference curve was, right? And that would be perfect compensation. When we were talking about tort law, perfect compensation would put the person that was injured back to the same indifference curve. And we made the discussion about what if, there was, you caused them injury and they couldn't be restored to their old health situation, then you would give them some money to make it so that when we drew the indifference curve, right, we had income and health on the two axes, and we said you want to put them back to the same indifference curve. Maybe they won't be able to get to the same health side, so you got to give them some compensation, not just pay for their medical. So, but what we're trying to do here is we're trying to impose a cost on the criminal, right? That's what we're trying to do. We're trying to impose a cost on the criminal of committing the crime. So, I mean, just some standard examples. We throw you in prison, right? Or we restrict your activity like driving. I don't know if you ever read the Hillsdale Daily News. You probably don't, but yeah, actually, it's sort of fun to read just to see what's going on, especially if you look at the sports thing. Like Patrick Flannery's kid plays soccer, right? I don't know if you know Mike Roberts, who's the coach at the Hillsdale Academy, right? His daughter just won the, I think the regionals in cross country, right? So you wouldn't really know that unless you get the Hillsdale Daily News. So anyway, if you look in the Hillsdale Daily News, it'll also say, here's what arrests were made, okay? And one of the things that they might do is, if let's say you got convicted for drunk driving or driving without a license or something like that, they may restrict your ability to drive. Okay? So, and you see people that were arrested for driving when their license was suspended, right? So you could suspend somebody's driver's license. You could have them pay fines. You could have capital punishment, right? Not every state has capital punishment, but some states do. And so you can think of all sorts of ways that you might, it's a cost to the criminal. It's a punishment rather than a compensation, right? And we just said that as opposed to, as we said, like tort, what are you trying to do? You want perfect compensation. You want perfect compensation for the victim. So these are separate things, right? I'm not trying to restore the victim to where they were. I'm trying to punish, I'm trying to impose a cost on the criminal law. So, and criminal law is about intent, right? So what we said, you have to have an intent to do harm, whereas, tort law was accidents. And so what are you trying to do? You're trying to make the injurer worse off. Right? You're trying to make the injurer worse off. You're not trying to compensate the victim. You're trying to make it so that the injurer is worse off when they do this. And that is because if we're looking at it from an economic point of view, and we already talked about this when we talked about Gary Becker's book on the economics of criminal behavior, what we're trying to do is to think through, let's just look at what we normally assume when we're talking about behavior of a rational individual, right? A rational individual is trying to make themselves better off. And so what are they doing? You look at when the marginal benefit is bigger than the marginal cost. Okay? We teach that in ECON 105. Okay? You keep doing something as long as the added benefit to you is bigger than the added cost. So what we're doing in tort was we were trying to get precaution. Right? We want to take the optimal amount of precaution, right? We've talked about this numerous times. That is, if you increase the precaution, there's a cost to doing that, but there's a benefit to doing that because you reduce the expected loss that could happen, and you keep undertaking precaution. An efficient amount of precaution is where what? The marginal cost of the increased precaution is equal to the marginal benefit of the diminished expected loss, okay? But that's not what we're talking about here. We're not trying to get people to take proper precaution. What are we trying to do? We're going to say in criminal law, the criminal, what are they trying to do? They will look at the marginal benefit bigger than the marginal cost of a crime, and if so, they'll commit. Right? So you're going to keep committing a crime if the marginal benefit is bigger than the marginal cost. Different idea than I'm wanting you guys to take the efficient amount of precaution. Okay? So you could have both, right? You could have both where you pay a fine and you compensate the victim. Right? Again, you could combine this. You could say, okay, you had intent, you caused harm, and so the punishment is we're going to make you pay a fine to the state, but we could also make you give something to the victims. Okay. Again, it'll be interesting to follow this opioid case and see what's going on there, whether they have criminal activity. Again, we've talked about this, about criminal activity of the owners of the company, and if they do end up charging them with a crime, and let's say they're found guilty, just look and see what they have to do. Do they also, out of their own assets rather than the company's assets, do they make them pay a fine, and then they also give something to the victims? I mean, something like that could come up. So essentially, you could do both. But the point is to make the injurer worse off. That's the key here. You want to make the injurer worse off. Right? Then if they were to not commit the crime, right? So you want to make them worse off if they commit versus no crime, right? So again, it's just not rocket science here, but the point of criminal law is, again, just emphasize to not restore the person that is the victim to where they were, but rather to punish the person that could be undertaking the crime. All right. So now let's talk a little bit about in section 2 of this chapter in the book, where we're talking about just examining some things from an economic theory point of view. First thing, so again, if you're following along in the text, this is section 2 of the chapter, and they call it economic theory. But the first thing they talk about, or we're going to talk about as well, is why do you not just use tort law, right? What's sort of an inadequacy of tort law, and therefore a necessity of criminal law? Okay. Again, tort law resulted in efficient precaution that, if we set it up right, we noted that if you had strict liability, then you got efficient precaution by the potential injurer, but not efficient precaution by the victim. If you had no liability, you got efficient precaution by the victim or potential victim, but not by the potential injurer. And in order to solve that problem, we used negligence, where there was if you knew what the efficient precaution level was, you would say if you undertook that efficient level of precaution and you were the potential injurer, then you go from strict liability to no liability, which is a big drop in the cost when you hit the efficient precaution. And you had the same thing on the other side. That is, if you were the victim and you didn't take sufficient precaution, then there's a no liability. And so there's a big drop for you at that point. So both parties know that there's a big incentive for the other party to be undertaking proper precaution. And so the potential injurer knows that there's going to be a strict liability if they don't undertake proper precaution, and the potential victim knows there's going to be no liability if they don't undertake proper precaution, and so they both will undertake proper precaution, right? And we gave you the 4 different ways of negligence rules, and we said that they all result in efficient amount of precaution. Okay, but what are you trying to do? And the same thing with contract law, right? And we said there's a problem in contract law that how do you put in the efficient precaution part, right? And in the end we said, well, maybe you could do hypothetical expectation damages, right? But then you sort of got to guess what the return to the promisee would have been had the promisee taken proper precaution and the contract had been fulfilled, et cetera. We said that's pretty hard to do, right? But what we're talking about here is, or talking about there as well, is that can you get the people to internalize the cost of the crime, right? So can I get parties to have all the costs, be thought out for myself and internalize the cost? And the answer is, as we looked in tort and contract law, we were attempts to get you to internalize the cost, that is, realize what's going to happen to the other person as well. Can you internalize the cost of the crime? And generally, the idea is no, right? It's difficult to make that happen. So, first, why might that happen? Well, in tort law, we talked about how difficult it is to provide fully compensation in some areas. And then we said, what if somebody struck your child with their car and killed him, right? How do you have perfect compensation? How do you move that person back to their same and difference curve? It's pretty hard to do, right? So it may be that there are certain harms that you can't fully compensate. Right. So so what we really want to do is we want to deter the risks more than what the damages could do, right? More than what we could do if we were to make you pay damages. So we want to more than if you paid damages. So we're going to we're making a criminal law, right? That is, we're going to use criminal law rather than, because we really want to keep you from doing this, right? Because there's some things that are very hard to compensate you for, so we really want to deter this behavior of yours. And if what we did was we just, if it were something like I stole $100, and we'll come back to this in a moment, but let's say I stole $100 and I had to return the $100, then you sort of know what the compensation is. But if you kill somebody, how do you get you, when you're deciding whether to kill the person or not, how do we get you to internalize those costs, right? You're going to say, okay, how can I get the person, how can I know what that compensation ought to be? It's really going to be high. And so what we're going to do is we're going to use criminal law to offset this. We're going to make it so I just don't want you to do such a thing because it's just the expected costs are so high. So we would use criminal law to do that. And again, it's to deter behavior, right? The purpose of criminal law is not to compensate, but to deter behavior. So again, I'm going to use criminal law to make it so that it's expensive from your perspective as the potential criminal to go ahead and to do that. And in a second thing that we were talking about just briefly here is it's to prohibit intentional harm. that is, again, remember we were talking about under property law that this idea of a property right versus an interest in the party, or excuse me, an interest in the property. Okay? So that, remember when we were talking about trespass, we could say that I might trespass on your property and compensate you. Okay? And what was that? That was a forced sale. Okay? And we were trying to decide where to assign the property right, but it's a right to use the property in that sense. So you have a similar idea here, is that people have a right to go about unharmed, right? That is, people have a right to go around or go about their business. We're going to say, I'll just write go about their business unharmed. Right? So you have a right to this, and so what is the idea here? The criminal law is about giving you a property right. Okay? That is, if what we're doing here is we are preventing a forced sale of the right, right? Whereas when we allowed you to trespass and pay compensation, then what was that? That was a forced sale, right? Whereas you don't want to have that here. We're going to try. You have a right to go around, not have your stuff stolen or not be threatened by somebody trying to shoot you, and so that property right is yours, and we're going to make it so that the criminal can't go ahead and violate that property right. Yeah?
So could you say that the whole point of criminal law is to make sure that the marginal benefit is never greater than the marginal cost?
That's exactly right. The whole point of this thing, and we're going to talk in more detail about this, is that if you have a rational criminal, what am I trying to do? I'm trying to make it so that the marginal benefit to them is less than the marginal cost to them of committing a crime. And we'll talk about number of crimes or severity of crimes or whatever, but that's what we're trying to do. But from a property rights perspective, if we're just looking at it that way, why might you use criminal law? It's because we're going to say, you know what? We have a right to go about, we have, in a sense, a right to a situation where we don't feel threatened. And that's one reason that we're using criminal law as opposed to tort law, where I can sue you for stealing from me. I'm trying to make it so that you don't even think about stealing from me because I have this right that you can't buy from me. But that's exactly right. If we're thinking about rational economic behavior, and if that's how we're going to look at crime, and again, whether criminals actually act this way or not, we'll talk about that as well. But what we're trying to do is reduce the marginal benefit of committing crimes and increasing the marginal cost from having crimes. Again, if we look at the expected value of stealing, which we're just following up here in this conversation here, the expected value of stealing. Okay, if I look at the expected value of stealing, if I had to just pay compensation when I was caught, okay, if I only paid compensation if caught, what's the problem? Well, the problem is I'm going to look at the expected value of being caught, right? The negative expected value, or we might call that the expected cost to me. I'm going to look at the expected cost. So, if you have a rational criminal, they're going to look and say, oh, guess what? there's only a 90% chance that I'm going to be caught, right? So suppose that you steal $100, and if what we did was you had to pay $100 if you were caught, it'd be indifferent between stealing and not stealing, right? But we don't know that you're going to get caught, right? We don't know that you're going to, and if can talk more about this later, but not only do you have to get caught, you have to get convicted as well, right? And so what are you looking at? If you are a rational criminal, what's the expected value? What's the expected value, right? This cost, it's the probability times what you have to pay. So if what I did was I just had compensation where you just got to give back what you stole, it ain't going to work, right? Unless you have 100% certainty that the person's going to get caught and have to pay back what the amount that they stole, then and that would make them indifferent. So because I'm not just about restoring the individual, I'm going to want to make this. Even if I'd want to have the compensation or the amount, the fine, I'd want to have the fine bigger because I'm trying to deter this thing because it's causing public harm as well, right? But even if I didn't think about that fact, I need to have that you're going to have something of greater, a greater fine or a greater punishment than whatever it is that you stole, right? So I got to have something bigger than what compensation is. So when we're looking at deterrence, I'm going to say, which is we're trying to do, right? So when we're looking at deterrence, we got to sort of guess if the act was a rational decision or a spontaneous act, right? Or spontaneous. That is, if what's happening is you plot to commit a crime, okay? You plot to shoot somebody, which you're the person that went up in the went up in Las Vegas or wherever it was and started shooting people from the hotel. Okay, they thought about doing that, right? Or did you just get in a fight with somebody at a bar and you hit them? And caused brain damage and killed them, okay? Those might be two different ways to look at it. What we're trying to do here is we're analyzing this as a rational action. And so you might want to have different punishment weighted on the deterrence how much deterrence actually comes from the punishment. If it's a spontaneous act, then probably not as much, right? What that tells you, what you might want to have is you might want to have greater punishment if the person plotted the crime or you knew the person was out there clearly making a rational decision about what they were doing, right? They thought about it. As opposed to all of a sudden something happens, you're at a Trump rally and somebody irritates you and they are carrying a gun and it looks like they're going to go for their gun or they put their hand on their gun and you just all of a sudden shoot them, right? You weren't plotting to shoot the person from the beginning, okay? So it may be that you have to make, again, a judgment over and over again, we've been talking about this, is that give you some guidance on what the law might be, is that you might have greater punishment if the act were planned versus spontaneous. Right? I might go ahead and say, okay, if there was clearly the intent, the person thought about it, etc., then deterrence is going to work, right? Punishment is going to work to deter that. How much deterrence is there out there for increasing severity of the punishment if this is just something that happens spontaneously without the person thinking through it? So what you might want to do is you might have greater punishment for plotting, or for greater punishment for repeat offense. Right? This is the third time that you've shot somebody. Okay. Well, maybe it isn't spontaneous, right? Or this is the third time that you've gotten a fight, okay, and harmed somebody. Maybe this isn't spontaneous. Maybe this is sort of planned. So, and notice that you have that. I don't know if you follow, court cases at all. You oftentimes they have a. If you again read the Hillsdale Daily News and they talk about what happened in the court, you'll see that, okay, the judge said they were a repeat offender, and that's why they gave, there's usually a range of punishment that the judge can order. If they are a repeat offender, then they'll get a higher punishment. And of course, again, that's what you got to look at what is the amount of deterrence out there. So just quickly in summary, when should you have punishment? That is, rather than compensation, what we just said is that if we say punishment over compensation, and what we just talked about was what happens if you have imperfect compensation. The second thing we talked about was what happens if you want to protect the rights of the individuals. You have a right to safety or a right to not have fear. And the last thing then we said is, are there enforcement errors? Right? So there's the probability, we'll call that enforcement errors, but what's an enforcement error? That is, there's some a probability of less than 1 that you'll be punished. Right? So then you got to have something that makes the expected cost greater than the benefit that you're going to get from whatever crime you did. All right, so for Friday, we'll start to look at rational crime. Okay. Now, and remember that we got the review session on Thursday. Again, I'm trying to zoom this one, so they've got a new camera thing here, and so we're going to hope that all works out. But in any event, I'll try to zoom the Thursday review session for people who can't make it at that time. So again, it's 8 o'clock Thursday night. All right? Do you have any questions? Send me an email. Let me know. Call me. All right?